justice finding judges to deal with that level of trials that will now be required. Well, he told me it's assuming that we will have a trial, and that's true. But that is also tied into what the learning director said about plea bargaining. What is there to persuade persons to enter into a plea when they know they can hire a defense attorney, they can frustrate the process, they could confuse a jury, and most likely be acquitted? You tell me you're abolishing juries. I'm happy about that too, but I'm coming to that. When I think it's the Honorable Attorney General, someone said before that there are 500 pending criminal murder indictments. Now, when we eliminate the preliminary inquiries, we now may push that up to about 800, 900, 1,000. I am yet to understand why the average trial, criminal trial in Trinidad and Tobago is now lasting months. There is one that is going on now. I don't want to be, and this does not resemble any present ongoing matter, which has crossed a year. And I don't want to cause the judge any stress, but it seems like it will be going for another year. Now, how could you have a trial and it seems like it's going to rival the Maurice Bishop trial? How can you have a trial running for over a year where you have a jury? Just this week I was thinking, but these people may have a business, they may have a small business. What's happening to the business whilst they are away every day sitting on a jury for a year? Or they may be a single employee in some small enterprise. Is the employer required to hire a replacement because under law he has to continue to pay that employee? So the elimination of the preliminary inquiry is not the answer, it will just push it up to the High Court. And corresponding with that move is the introduction of plea bargaining, which I'm happy the Attorney General has been able to get going. But I also think that, and this could be controversial from the position of the bar, from the private bar, I think we need to eliminate jury trials. Because you are having a jury sitting there for months listening to evidence, and the trial judge is burdened with trying to summarize that evidence. But you're telling them complex concepts that law students will take years sometimes to understand, and some of my colleagues still don't understand it when they But you're asking jurors to understand complex concepts of law and apply to the evidence. And then you have complex frauds. I remember advising during the course of an investigation in a fraud matter, a very complex fraud. And I remember someone said to me, and he has a PhD in finance and about 2 or 3 MBAs. He said to me, Gilbert, will this thing ever get a trial? I said, well, I hope so. And I am really hoping so. But he said, but I am a man in finance and I have to read this thing over 3 and 4 times to understand what happened. So right away that brought home to me the need for special juries. And I see the amendment the Attorney General has introduced cater for special juries. But I think it would be advancing the system if we were able to eliminate juries. But as I was saying, the answer to the problem is not eliminating preliminary inquiries, but I think if we eliminate them, it's a first step. But we must have robust case management rules and case management conferences. And the trial judges will have to be firm in order to have defense attorneys in particular disclose their defense. So AG, I think you have to also introduce disclosure rules that will cause mutual disclosure.